Welcome to Evidence Module 11 related to Federal Rule of Evidence 411. This is the last of the 5 rules of specialized relevance that we will be studying. We can now go from being a sap to being sappy. Rule 411 has 3 chief features. First, it is a rule of limited exclusion. Evidence that a person was or was not insured against liability is not admissible on the issue of whether the person acted negligently or otherwise wrongfully. Second, the rule contains an illustrative, not an exhaustive list of permissible uses of liability insurance evidence. That is, the rule does not require the exclusion of liability insurance evidence when it's offered for a purpose such as proof of agency, ownership or control, or bias or prejudice of a witness. Again, this rule is just illustrative. A litigant could come up with a creative other purpose not mentioned in Rule 411 in order to dodge the limited exclusionary rule. Third, Rule 403 is looming in the background, and parties must make sure that the evidence survives Rule 403 as well. Now, what are the rationales behind this rule? First, relevance. Evidence that a person has or does not have liability insurance has limited probative value. After all, the fact that a person is insured for liability could signal that the person is careful. They insure themselves against damage. It could also signal, however, that the person might not be especially careful. After all, if you're insured, maybe you can take more risks, because if you injure somebody, the costs are going to be absorbed primarily by the insurance company and not by you. Likewise, someone who's underinsured or not insured might take extra precautions in order to ensure that a damage does not result, because the costs would be borne by that person. However, the fact that you're underinsured or uninsured could signal carelessness, that you don't bother to seek protection against the possibly inevitable type of accident. Moreover, evidence related to liability has a high risk of unfair prejudice. A jury that learns that one party is insured for liability might sock it to that party based on the idea that a party that is insured has deep pockets and that the insurance company is going to have to pay up, not necessarily that individual. Finally, public policy suggests that we want to encourage people to insure themselves. We don't want people to make decisions about liability insurance based on how it might play in front of a jury.